Welcome back to Takis McGinnis Elder Care News Hour. I'm Barbara McGinnis, and in today's episode, we're talking about how the judicial system gets involved in elder care issues, specifically probate, conservatorships, and mediation.
And I'm your host, Tim Takis, and we're going to continue our conversation with Davidson County's 7th Circuit Court Judge, Randy Kennedy. Judge Kennedy's court not only does probate cases, but also conservatorships and guardianships, which can be another misunderstood issue. Welcome back, Judge Kennedy.
Thanks for having me.
So what is a conservatorship, and when is it needed?
A conservatorship is a legal proceeding wherein members of a family or other interested parties seek to have a disabled adult, rendered incapacitated by law so that someone can be appointed to manage their personal and or financial affairs.
Okay, and a guardianship is? A
guardianship is distinguishable from a conservatorship in Tennessee in that it deals with minors or individuals who are under the age of majority, which in Tennessee is age 18.
Right, so today we're talking about pretty much conservatorships, which is for older people, adults. Exactly. So,
well, what if a family, an older person, has a valid power of attorney designating their agent? Do they need a conservatorship?
You know, the answer to that is it depends on the family. You know, my own mom is 90 years old, and she designated a health care power to my younger sister, who handles her personal needs and her health care needs. She designated her durable power of attorney, which is for finances, to me. So she asks me to assist her financially. When someone does a power of attorney, if they appoint someone in whom they have an infinite amount of trust, who they know will do a good job and who they can deal with on a daily basis, then you can escape the need for a conservatorship in many of those cases.
Especially if there's harmony in the family, if consensus in how that older person is being taken care of. You're doing a good job as mom's agent.
Right.
Sister doesn't question what you're doing.
Right.
And so sometimes a conservatorship in those situations come up if there's discord, distrust among the family members, or if just questions that mom's not being well taken care of.
Absolutely. And of course, you know, with the power of attorney, if you have a family that's in harmony with one another, you know, if mom wants to fire son and hire a daughter, or wants to fire a daughter and hire a son, she can do that. She can discharge them and change her mind and make a decision, at least until she becomes so disabled that she's unable to make decisions. But there's a distinction. I would say the vast majority of cases, however, where there's not harmony in the family, a conservatorship is probably advisable.
Yeah, and that's where we say sometimes to people that maybe come into our office who are maybe not so harmonious that we have to send them somewhere else, you know, and we'll say to them, it says, well, if you can't agree on how to take care of mom, I'm sure Judge Kennedy will tell you, you know, how you should take care of your mother. Is that really what you want?
Right, which should be an incentive not to come to our court if you can do it.
Not that you want to help, you know, make those decisions, but obviously somebody needs to. So, so how is a conservator appointed? So the person applying for a conservatorship isn't always the person that asks for one, is it?
That's true. Generally speaking, an individual who's either a family member, an interested party such as a neighbor, a friend, someone who holds a power of attorney over which there's a dispute. Occasionally, Adult Protective Services, which is a division of the Department of Human Services, will file their own petitions, or someone else may bring a petition. Once that petition is filed, this court is required, all the courts in Tennessee are required, to appoint a guardian ad litem, except in exceptional circumstances, to become the eyes and ears of the court, to go out and investigate the facts, to look at medical records and financial records, and to look at the standing of the proposed conservator who filed the petition, so as to be able to make a report and a recommendation back to the court.
Does it take a long time?
You know, most conservatorships can be wrapped up in a matter of a month or 2 months. The appellate courts have guided the trial judges like myself to say that we should have a final hearing of a traditional conservatorship proceeding within 6 months of the date of the filing of the petition.
Right, so let's get it done, get it out of the way, make sure, because I'm sure that sometimes the person maybe needs to be protected.
Yes.
I know that sometimes we hear about cases involving an emergency conservatorship.
Right.
I'm trying to think, who was it recently? I think that you have a very well-known case.
Well, I've done several. Some of those are under seal, and I probably shouldn't comment a whole lot about them. But there have been a number of our citizens here in Nashville who had complicated, extended families with significant assets and allegations where some family member might have been taking advantage of them. And in those cases, an emergency conservatorship usually takes hold. In fact, you're probably aware, Tim, that we do more emergency conservatorships in Davidson County, Tennessee, than in any other county in the state of Tennessee, and in this court particularly, at about a rate of about 250 of them per year.
Wow. So one a day.
Yeah, one a day is coming through, and of course a lot of those are not necessarily because of financial exploitation. A lot of those are because of traumatic brain injury. Someone perhaps is in a hospital in a coma, and they didn't designate a power of attorney, you see, or they didn't designate someone to handle their affairs.
Right. Are there different types of conservatorships?
There are. I put them in three categories. There's a traditional conservatorship that can be divided up into three categories. The traditional conservatorship is one for personal matters, or for financial matters, or for both. That's the traditional conservatorship in Tennessee. There's also the Uniform Veterans Guardianship Act, which is another form of conservatorship exclusively designated for persons who are veterans of the United States Armed Forces. And then thirdly, we have, of course, guardianships, which, as we talked about earlier, for minors, children under age 18, and some of those will transfer into conservatorships. And then if there's a fourth category, and that's the emergency conservatorship category that you've already brought up.
So what does it cost to get this whole thing started? Now, certainly there's probably a filing fee, and who pays for these things?
The filing fee, if a petitioner comes in to file a petition to have someone appointed as a conservator, they pay a filing fee, which is really no more than a couple of $100s. Now, the rub is whether or not you're going to have a contested case or not. If it's an uncontested case, the fees that are associated with an uncontested conservatorship case may be as low as $1,000 to $2,000. If a conservatorship is contested, like the one that you mentioned, that I'm kind of leaving the famous individual nameless, the fees in that case have been in the tens of thousands of dollars because of the protracted nature of that litigation.
Now, those fees, as I understand, the guardian ad litem's fee has to be approved by the court.
They do.
Fees for the petitioner's lawyer, I think, are approved by the court.
They are, unless the petitioner decides to pay those fees out of their own pocket, separately by contract. In fact, all fees in conservatorship cases, other than those, must be presented to the court for prior court approval. And we have local rules of court as well as state rules that mandate what the lawyer must submit in the way of records and time records and affidavits in support of their fee request.
Because I believe the fee is actually paid by the disabled person's assets.
That's
is that
correct.
Right?
If in fact the disabled person is deemed to be in need of a conservatorship, then in those cases, if the fees were found to have been for the benefit of the respondent, the disabled person, the court will charge those fees against the disabled adult's estate.
You know, you've mentioned some of the responsibilities of the conservator, not reporting to the court, submitting fees, requests for fees. What are some of the other responsibilities that they have? You know,
what the primary objective or the primary duty and responsibility of any conservator is to do what is in the manifest best interest of the disabled adult. That's the overriding obligation. And underneath that obligation, there are a myriad of areas where there may be responsibilities. For example, if they're managing the finances of the disabled adult, then they're going to be required to file inventories, accountings, interim accountings, file tax returns, make dutiful reports during the year about how the respondent or the disabled person is doing and whether or not they still need to have a conservator.
And I've heard you say many times in court, even if the accountings are waived or bond is waived, they still have to file that annual status report to let you know where the person is and how they're doing.
Absolutely. Judge Clement, my predecessor, once said that anyone who's been appointed as a conservator becomes a fiduciary. That's a fancy word for a person in a position of trust.
Yeah.
And when you're a person in a position of trust, you've got to do certain things to take care of that individual.
Well, Judge
Thanks,
Kennedy,
Judge.
thank you very much. We're going to put your contact information up here.
And we're going to go to break right after this. And when we come back, we're going to be talking with the Office of Conservatorship Management. Don't go away.